What up, though, Biz Nation? And it's your boy Tay Biz. Check it out. We have a video today that we're dropping about your boy Diddy. We got a couple of things we want to cover. Number one, we want to cover a lawsuit that has been filed, or that's being filed, or has been filed from an anonymous male celebrity claiming that Tony Buzbee is extorting them. And so Tony Buzbee is the attorney that is representing 120 alleged victims of Diddy. All right, we're going to cover that real quick, get into some details with that. And also, we're going to cover this whole thing about Diddy blackmailing or trying to bribe victims while he's in jail. For some reason, I don't understand what's going on with that, but we're going to cover that as well. We're going to get to some details about that and see what actual attorneys are talking about or actually seeing when it comes to this situation. But the prosecution has stated that they have heard and seized some of the jail calls and jail cell notes showing that Diddy has made phone calls to his family and things of that nature to reach out to victims and bribe them, or, say some things to make sure they don't be witnesses, if you will. All right. So without further ado, let's go ahead and get into this real quick. Let's go.
Men and women are now accusing Sean Diddy Combs of sexual assault, false imprisonment, and numerous other sex crimes. The music mogul has already pleaded not guilty to federal charges, including sex trafficking. CNN's Elizabeth Wagmeister spoke with the accuser's attorney.
More than 100 new accusers plan to pursue legal claims against Sean Diddy Combs, according to their attorney.
These were people that were there, that were allegedly drugged and then allegedly raped, passed around, woke up the next morning with just completely clueless about what had happened to them.
Combs denies the allegations, his lawyer telling CNN in part, Mr. Combs emphatically and categorically denies as false and defamatory any claim that he sexually abused anyone, including minors. Combs already faces a dozen civil lawsuits and has pleaded not guilty to charges of racketeering conspiracy, sex trafficking, and transportation to engage in prostitution. Houston attorney Tony Buzbee tells CNN he intends to file individual lawsuits against Combs for each of the 120 new accusers, some who he says have already spoken to the FBI.
Do you have video evidence of your clients allegedly being sexually abused?
It's full-on video of things happening that would never be appropriate for public viewing.
Buzbee says he's in the process of collecting video, photos, text messages, medical records, and drug tests.
Many of your clients have alleged to you that they were given a horse tranquilizer.
You hear that one time and you think that's really strange. You hear it 3 or 4 or 5 times, all of a sudden you're like, holy, well, what is going on here?
In the indictment, federal authorities also accuse Combs of drugging victims.
They do not believe that Sean Combs acted alone.
I do agree with the FBI and the federal authorities. I do think that there were a lot of individuals involved and a lot of entities involved.
Household names, are we talking about celebrities, executives in the entertainment industry?
All the above, yes.
We've all heard about the white parties. Just because a celebrity is photographed wearing white at a Sean Combs party does not mean that they are complicit in any criminal activity.
The white party comes up quite often and typically later in the night with the same MO, a drink laced with something in some cases.
Was this all happening in plain sight at these parties?
That's the allegation, that people saw exactly what was going on and did nothing about it.
So that's just a recap from Tony Buzbee and CNN talking about these alleged victims and things of that nature. He did file some lawsuits, I believe, about a month ago concerning this particular situation, going after Diddy, right? I believe it was about maybe 13 to 15 lawsuits or something of that nature. However, there is an anonymous male celebrity who says he is a victim of an extortion scheme and is suing a high-powered Texas attorney who is representing several people in civil lawsuits that accuse Sean Diddy Combs of sexual assault. So this particular celebrity is going by John Doe, which is the pseudonym this week in the Los Angeles Superior Court. It says here that he has accused Houston-based attorney Tony Buzbee and his firm of shamelessly attempting to extort exorbitant sums from. Says here he has accused Houston-based attorney Tony Buzbee and his firm of shamelessly attempting to extort exorbitant sums from him, or else publicly file wildly false, horrific allegations against him. That's the quote. Says here that a spokesperson for Quinn Emanuel, the law firm representing Doe, confirms that the complaint was filed on Monday. Okay. Buzbee has said he is representing at least 120 alleged victims of Combs. Over the past month, he has filed more than a dozen civil lawsuits against Combs, in some cases accusing the producer of drugging and sexually assaulting plaintiffs, some of whom alleged they were minors at that time. The lawsuit filed by the anonymous celebrity claims that Buzbee's firm is trying to capitalize off the explosive allegations against Sean Combs by roping in public figures who have been acquainted with Combs. It says here that the attorneys for Doe claim that Buzbee sent a demand letter earlier this month in which his firm threatened to unleash entirely fabricated and salacious allegations of sexual assault that include multiple instances of rape of a minor, both male and female, if their client refuses to comply with their demands. Tony Buzbee is being accused of pretty much spearheading a more of an extortionist type of campaign or approach when it comes to going after Diddy and all the people that were involved. He claims to have video. He claims to have all these certain things. So we will see what happens. Now, with that being said, we do have Diddy, who has been in jail. We do know that he's in New York, and he has been making phone calls to family and friends and things of that nature. And for some reason, he's telling them to go talk to the other people, victims, about this case, about this thing going on. So what I want to do is I want to go ahead and play this video. We're going to go ahead and look at it together, and then we're going to see what's going on, get some more details about this. This is absolutely insane. The prosecution already seized his jail calls and his cell notes. So let's see what happens. Let's take a look.
Bombshells after bombshells in the government's new filing in the Sean Diddy Combs case, the sex trafficking, racketeering, prostitution case. I don't need to repeat all the allegations. You know what they all are by now. But prosecutors from the Southern District of New York submitted an opposition brief to Sean Combs' motion for bail that they are hoping that this new judge, in this case, Judge Arun Subramanian, will hear. And as we're going to lay out, prosecutors say not only is Sean Combs not entitled to bail, but essentially he shouldn't even get a hearing on this. And remember, Combs is currently in detention at the Metropolitan Detention Center out in Brooklyn, New York, after being denied bail by other judges. The main issues keeping him locked away are that the courts have held that the prosecutors have shown that he is a danger on the outside. He's a potential flight risk. Most notably was evidence put forward that he had been improperly contacting victims and witnesses in this case. And as we discussed on previous sidebars, Sean Combs' counsel has denied all this. They've indicated that all of those conversations were not done with the intent to engage in witness tampering or obstruction. And even, at least they say, one witness had contacted Combs, not the other way around. Well, the government has come out with new evidence of its own to justify pretrial detention. And let me just read you this from the beginning of their brief. They say, while attempting to evade law enforcement monitoring, the defendant has, among other things, orchestrated social media campaigns that are, in his own words, aimed at tainting the jury pool, made efforts to publicly leak materials he views as helpful to his case, and contacted witnesses through third parties? What? And that's not even half of it, because now we have a better idea of also who may be a key witness in this case. So much to break through, so much to break down. Let me bring on acclaimed criminal defense attorney to the stars, Bradford Cohen.
You know what's so crazy? What's so crazy is the fact that Diddy filed a bail proposal to the judge for him to get out early, right? I don't think we had any type of response from the judge yet. I think he did this like about a week ago or so. I think it was like Friday. It was on a Friday. And so now here it is, you have this bail proposal, and then you're doing this. Like, I don't understand what his MO is, man. But let's go ahead and take a look at this again, man. Like, let's continue this. This is crazy. Like, dude, you're already proposing to get out of jail, and now this is not helping you at all.
Thank you so much for coming on, Bradford. I got to start with this bombshell. So the government's acclaimed criminal defense attorney to the stars, Bradford Cohen, who has famously represented celebrities like Kodak Black and Drake. Thank you so much for coming on, Bradford. I got to start with this bombshell. So the government says, look, you can't let him out because he has already been engaging in obstruction while locked up. They read, the government has reviewed dozens of recordings of BOP jail calls in which the defendant uses telephone accounts of at least 8 other inmates, which is against BOP regulations. Seemingly to avoid law enforcement monitoring, the defendant uses other inmates' PAC numbers to make phone calls to both individuals on the defendant's approved contact list, as well as other individuals who are not on the approved contact list. To obtain or maintain access to other inmates' PAC numbers, the defendant directs others to pay the inmates, including through payment processing apps and BOP account deposits. The defendant also frequently instructs individuals whom he contacts by telephone, including family members and his attorneys, to add other individuals via 3-way call. This practice is not authorized by BOP as it helps conceal the identities of the contacted individuals. The government has reviewed multiple calls in which the defendant has instructed parties to dial in third parties, including members and associates of the enterprise and individuals who are not on the defendant's contact list. Bradford, what do we make of this?
Not much.
Really? Not much?
Yeah. So this happens all the time in like every single case. They only make a big deal about it in this case. So the third party calling, when I can tell you in my 30 years, 28 years of practice, third party calling has been done in probably 90% of the cases that I have. In fact, sometimes third party calling to me. So what they would do is they'd get one of their friends on the line, and then that friend would then third party me in. And I always have to tell them, hey, this is an attorney-client privilege. You got a third party on the line. And when you have a third party on the line, anything we say is not attorney-client privilege. Sometimes, and this was really funny, I had a murder case in Tampa where they third-partied me in. So it was the defendant calling his friend and his friend calling me. And I knew that the prosecutor was listening, and I didn't give that warning. I didn't say. Yeah. And then I said, you know, hey, listen, we got evidence that are going to blow the doors off of them. And I knew she was listening, and I wanted to prove a point to my client. And then we went into court, and she's like, oh, I heard this conversation with Mr. Cohen. It wasn't attorney-client, and he said he's going to blow our doors off with this new evidence. I want to see this new evidence. And of course, we didn't have that new evidence. Yeah. So the third party, I just wanted to prove that the prosecutors, the smart prosecutors, especially in the Southern District of New York, are listening to every single phone call that you make. That's number one. Number two is, the thing about using other inmates' numbers, that happens a lot too, because them
getting paid for it? Them getting paid to use it?
Yeah, certainly. Yeah, that happens all the time.
And again, the allegation is not only that, but also contacting people who are not on his contact list.
Yeah, because some people don't want to be on your contact list. Some people don't want to be on the government's contact, because once you're on the contact list, the government now has your name, your phone number. They could tap your phone. A lot of people don't want to be on contact lists. So because of that, they might use, Bob Smith's PAC number and to call their friend. But they don't understand. It goes by the phone number, right? So, like, if I'm calling from Bob,
so why even be involved in?
They're looking for the phone number that I'm calling. They're not looking for Sean Combs. So if my number is 555-1212, they could just do a search. Who has called this phone number in the past month? And that's what they do. And then they realize, oh, wait a minute, why is Bob Smith calling this phone number? And then they go back and they listen to the conversation.
Yeah.
Really, what is the biggest thing? The biggest takeaway from this is that when you first get a client, and clients might not listen to you, and he might not be listening to his attorney, and his attorney is a very good attorney. He might have told him this at the very beginning. Right. But at the very beginning of cases, you have to tell them every phone call is recorded. Don't think that you're playing cute when you have PAC numbers and you try to call someone else. They're going to find out. And that's just the way that it is, especially in the feds. So I don't take much of it unless those phone calls are really damning.
So it seems like the attorney is not making a big deal out of the whole contact list or the third party or things of that nature, or people that's not on the contact list, because of the fact that it's not really, damning to the case. However, if what the person who is in prison is telling people that's on the contact list or not, or third party people, whatever, telling them to do certain things, like talk to this victim and see if you can get them some money to shut up, things of that nature, then that will be damage to the case. And they do have the jail call notes. They have the jail cell notes and things of that nature of who he's calling and what the conversations are about. This is a federal case. I mean, I understand that this man represents certain people and everything like that. But my thing is this: if you're in a federal situation, the best thing for you to do is nothing. Don't do anything damning to yourself or to your case. This is just a little bit weird coming from an attorney, I think. I don't know. I mean, again, being able to contact someone that's on the contact list, cool. Contacting people that's not on the contact list, third party, okay, fine, or whatever the case may be. But it's the content, it's the context in which you're talking that makes this damning or not damning to your case. So if I was Diddy, I just wouldn't do anything. I would just keep my mouth shut. I would just try to see if this bail proposal that I presented, the fourth one, to see if it actually go through this time, and just focus on that. Calling people and telling them certain things, or even if it's alleged, just don't even let nothing even be alleged to you at all. You already alleged enough. Don't be alleged anymore. All right. So, but that's just my quick little take on that part. So let's continue.
Well, what about, they say, quote, the defendant also uses a non-authorized third-party messaging service called Contact Me ASAP to obscure his communications. The defendant appears to be using two Contact Me ASAP accounts. First, the defendant's BOP contact list includes a particular email address assigned to the defendant's son, which does not appear to be an account owned by the defendant's son, but instead appears to be an email address connected to Contact Me ASAP. Second, the defendant appears to be using another inmate's Contact Me ASAP account, primarily using email one. The defendant has exchanged hundreds of text messages via Contact Me ASAP with dozens of individuals, including attorneys and individuals who are not on the defendant's contact list. So any issue there?
Again, if he's contacting his attorneys, it's usually, it always is attorney-client privilege, unless there's a third party involved. Some people don't feel comfortable talking to their attorneys on jail calls, even though they know they're not supposed to be listening to those calls. I can tell you, they do listen to some of those phone calls. They're not supposed to. They might not use it in a court of law, but a lot of times you find that they oh, sorry, by accident, I didn't realize it was his attorney until I was 3 minutes in.
Right.
So I don't take much of that unless, like I said, unless they have some damning evidence that he is doing something crazy on those phone calls, or he's doing something crazy on that application. Other than that, just using it.
I guess the counter argument would be, putting aside what the content is, we'll get to that. If he's breaking the rules of the prison, right? This is not the prison. If he's breaking the rules of the detention center, should he be on the outside? Is he going to flout the rules of his bail?
Exactly. He doesn't have room for error at all. That's a better
argument, but the problem is that, quote unquote, breaking the rules by making phone calls and things of that nature, unless those phone calls are the prohibited thing. Like if I am calling a witness directly and having direct witness contact by using this kind of obscure messaging and things of that nature, 100%. But I think just because he uses third-party calls, that's like, like I said, 99% of the cases do that.
Okay, so let me, there's just so much to get to, so I want to get through everything with you. So the prosecutors have indicated that they will produce these calls to Combs and his lawyers through a filter team prior to what is a scheduled bail hearing on November 22nd, 2024. We're going to be covering that on Law and Crime. But then they write this. On multiple calls, often using the PAC numbers of other inmates, the defendant is explicit about his intention to use public statements to alter public perception. And the defendant leaves no doubt that the narrative he wants to leave is the potential jury pool's perception of this criminal proceeding. And examples of these efforts, they say, are plentiful. And then they black out and they redact all of those examples. First, Bradford, why the redactions?
Well, the redactions probably because they don't want it to then make it public what his position is. Like, I didn't do it. This one witness, she did X, Y, Z. I'm sure that there's things in there that the government doesn't want the public to hear, because the government has their narrow view of what's going on, right? And whenever the defendant then wants to address that narrow view and put out his own statement or address it in a different way, they want to curtail that because they have a certain way to look at a case. They don't want anyone looking at it differently. I find this to be the most ironic thing. It's like, it's hypocrisy at its best, because although the New York Southern District office does not themselves leak things often, they have in the past, but in this case, I don't think there's any evidence that they leaked anything. They also know that other individuals are leaking things that help their case, and they're not curtailing it. Like the video of Cassie was certainly leaked. My guess is it was her attorney who leaked it. I don't know for sure, but I would guess that it would be her attorney who leaked that video, because that video was in their possession, and that video is something that helps her case to say, hey, I'm not a defendant, I'm a victim here. I will guarantee that the government knew that video was in their possession, and that the government knew that some individual was leaking that, and they could have found out who leaked it, but they don't care because it helps their case.
That's what Combs attorneys have been saying. Yeah, that's what Combs attorneys have been saying.
Yeah, and if it didn't help their case, 100%. And if it didn't help their case, they would then be curtailing it.
Well, here's a specific example that's not redacted, that's not blacked out about what they say happens, because they say after the court entered a gag order, by the way, to not disclose information about the case that applies to the prosecutors, investigative teams, law enforcement, but it also includes Sean Combs and his attorneys. The prosecutors write, the defendant enlisted family members to plan and execute a social media campaign around the defendant's birthday with the intention of influencing the potential jury in this criminal proceeding. And by the way, we covered this on Sidebar. We played that video for you where you can hear his kids wishing him a happy birthday. Combs is on the other line, seems to be happy. But the prosecutors write, at the defendant's carefully curated direction, the defendant's children posted a video to the respective social media accounts showing the defendant's children gathered to celebrate the defendant's birthday. The defendant, from within the MDC, the Metropolitan Detention Center, then monitored the analytics, i.e. audience engagement, and explicitly discussed with his family how to ensure that the video had its desired effect on
See, that's what I'm
potential
talking about.
jury
They
members
are on
in
his
this case.
head, man. He
Bradford,
don't have no
is
room
that
for
a
error.
stretch to say that this is tampering with the jury? Or could they say, hey, look, we're just trying to show positivity to change the public perception about him? What do you make of that allegation?
Yeah, I make it, I make very little of that allegation. Again, I think that, when you're in this situation and you can put out some PR that makes you look better than what they're saying. And listen, he's done a lot of good. It's not like he hasn't done good in his career. He has done good in his career, pointing out the good things that he's done in his career, pointing out that it's his birthday, pointing out that he's got a bunch of kids to quote unquote affect the potential jury pool. There is no jury yet. The jury pool could be from Staten Island. It could be from, Manhattan. I mean, the fact is that anything you put on your social media could affect a potential jury pool that we have no idea where they're pulling from, and we have no idea who they are. I think it's a huge stretch to say that would affect a jury pool. Would I think that it would affect, perception of Sean Combs? Sure. And what's wrong with that? He's not talking about the case. It's not a gag order on happy birthday to Sean Combs. And it's not a gag order to say, hey, at one point he gave, $50,000 to St. Jude's Hospital. That's not the quote unquote gag order.
So let me push back on that a little bit, because
Sure.
and this is something that I wondered, because his son had taken over his Instagram and was posting videos of his father's music videos and behind the scenes footage, and I was curious at the time about what the purpose might have been. But this is what prosecutors say in their filing. The defendant's own words make clear that his intent is to improperly influence the jury pool in this criminal proceeding. During other calls, the defendant makes clear his intention to anonymously publish information that he thinks will help his defense in this case. And then there's a portion that is redacted, but it also continues. The defendant's efforts to obstruct the integrity of this proceeding also includes relentless efforts to contact potential witnesses, including victims of his abuse, who could provide powerful testimony against him. For example, on October 4th, 2024, in a call involving the defendant and one of his adult sons, the defendant says, and then again, it's redacted, and then they write, provides the clear inference that the defendant's goal is to blackmail victims and witnesses either into silence or providing testimony helpful to his defense. So Bradford, in other words, they're saying, A, they have him on tape saying, I want you to put forward this social media content to help my defense. And B, communications about him trying to reach out to people in the case and maybe using his family. Now, what do you think about that?
So those are two different things. The first part of it about him reaching out about social media, I don't put much weight into it. I think it's something that every defendant that's popular will do. It's something that every defendant that is popular has done. When you have, these allegations, and there's certain allegations that, this guy's a bad guy, you're going to have social media saying that he's a good guy. And whether or not it is orchestrated by the defendant or orchestrated by a PR team, it makes no difference to me. The second part of that, if he's trying to reach out to witnesses, that's the part that, obviously is probably their strongest argument, right? If they have witnesses that are willing to come in or people that are willing to testify to say, hey, listen, he gave me XYZ in order to say XYZ, that's completely different. I don't think they have that, because if they did have that, I think they would be charging for every single witness that he has tried to do. The government is not just going to sit back and be like, oh, he paid that guy, we're not going to charge him for that. They're going to charge him for every single little thing that he has done or has attempted to do. So they, just not one count of obstruction. They could hit him with 10 counts of obstruction for every witness. I just don't know if that's what they have. I don't put a lot of faith in the allegations from the government when I have seen in my career those allegations fall short of what they're actually saying in those documents.
And I guess if they don't charge his family members or people that, he's charged with racketeering conspiracies, accused of reaching out to alleged co-conspirators too. If the government doesn't charge any of those people, what does that tell you? And by the way, should we anticipate charges against, family members? If this is what's happened, this is what the government's alleging?
If the government actually has the goods on this obstruction, then there would be no reason not to charge them. But the problem is I don't think they actually have the goods. I think that what they're really looking at is that individuals might have reached out to him to say, hey, listen, this XYZ happened to me. I'm going to file a civil lawsuit. I'm demanding $50,000. And it could be that they're settling civil lawsuits, and the government always feels when you settle a civil lawsuit that is under the guise of buying off a witness. That's always been their position. Doesn't matter what case it is, doesn't matter who you're representing. If there is a civil lawsuit that is pending or a civil lawsuit that could be filed that a potential witness says, hey, I want to settle and I want XYZ amount of money, and you give it to them, the government's position is always you gave it to them to buy their silence or to change their testimony. That's just the way that it always is in every case that I've ever had, and in every case that I've ever read about in terms of federal witnesses that also file civil lawsuits.
Bradford, I got to ask you about this part, because prosecutors say, they write this, quote, Then, after the defendant was in custody, BOP investigators recovered the following notes from the defendant's cell during a pre-planned nationwide sweep of BOP facilities. The strong inference to be
And here are
drawn
the
from the
cell notes
defendant's
that we were talking
communications
about
with Witness
earlier.
2, and I'll explain later on who that is, and his personal notes is that the defendant paid Witness 2 after she posted her statement. So, Bradford, first, we had reported that there was this sweep by the feds of the MDC, and maybe those notes were part of what they discovered. But then Sean Combs' team has just responded in their own filing today, and they write, defense counsel has recently learned that the prosecutors are in possession of attorney-client privilege material, including the defendant's own written notes. This search and seizure are in violation of Mr. Combs' 4th, 5th, and 6th Amendment rights. Moreover, the targeted seizure of a pretrial detainee's work product and privileged materials created in preparation for trial is outrageous government conduct amounting to a substantive due process violation. Because the prosecutors are currently in possession of privileged material and are actively using this material to detain the defendant, the defense requests an immediate evidentiary hearing. Two sides to this, Bradford. What do you think?
I side with the defense. As usual, I side with the defense. Not always, but in this case, to me, it really is outrageous that they're using his notes. And if it's work product, which I believe that it is work product, I don't think they should be able to. Think about this. They're going into cells and they're looking for usually weapons, illegal items, things that you shouldn't have, phones, cell phones and tablets, things that are snuck into the jail, drugs. And here he probably has a pile of paperwork or notebooks, and they start going through each notebook and reading them and determining whether or not these notes should be used against them in a court of law. It really is one of those positions where why you don't want your client in a jail situation, why you want him bonded out, because while he's in jail, if they can just do this, how do you contact your client? How do you give him paperwork? How do you give him certain things from your law office? How does he take notes to discuss with you the next time he's going to see you when you come to the jail? So he's taking notes in a notebook thinking like, this is what I want to discuss with my lawyer. And then they seize that and they go through it and they use it against you. I do think it's overreaching. I think that there is some case law. The only thing that I'm worried about is if they say this is some sort of crime or a crime fraud exception where the notes themselves are making reference to, obstruction or something like that. They could try to make that argument, but it's really a bootstrap argument because what they're saying is we seize the notes first and then we determine that they could be crime fraud exception. That's really the problem. It's not that they knew they were a crime fraud exception and they seized them afterwards.
I definitely get that part. I do get that part. I mean, you can't seize the notes of an inmate when they're talking to their attorney. It is attorney-client privilege. It is work product privilege. And so I do understand where he's coming from with that. My only concern is the fact that because of who this person is and because of the scrutiny that this person is having right now, I think that, of course, we know that the feds and the prosecution, they're not going to play fair on this situation right now, especially since they have evidence. I mean, let's be clear. We know that the feds have evidence of something here. Okay, so they're not just doing this for no reason. So, but I do think that there still has to be some attorney-client privilege. Again, you are innocent until proven guilty. We have to remember that. However, we also need to use some wisdom and say, you know what? I am walking a thin line right now. Let me not do anything to draw more attention to myself by doing certain things, And so when it comes to talking to your family and communicating with your family and things of that nature, that's one thing. But when it comes to, saying things like paying off witnesses or make sure you talk to this person for me or another co-conspirator and saying something through someone else to talk to that person, this is where it gets muddy. All right. And you can't come out the mud clean. So we have to make sure that we're still proceeding with a little bit more wisdom and caution, even though you still have rights and privileges under our Constitution here. You know what I'm saying? So I definitely get it right here. So let's continue.
First of all, before I let you go, because Bradford has to go, but we have more of this to go through, I wanted to ask you a big picture about this. Not necessarily whether everything we've talked about so far is about whether he's going to be charged with an additional crime. It's about whether or not he is entitled to bail. And that's the main issue. Based on these allegations put forward by prosecutors, and yes, it's a lower standard than we're talking about in a kind of a criminal case about a conviction of with a criminal charge. Do you think prosecutors could potentially meet the standard that he should not be released?
Yeah, I mean, listen, in federal court, it's very difficult to get bond on any case. Even the cases where you're somewhat entitled to bond, it's still hard to get because these prosecutors come in with these allegations, and no federal judge wants to give someone the opportunity to flee or to influence a witness or to do things. So a lot of federal judges, they don't want to stick their neck out if they don't have to, and if the law is on their side and there's some discretion there. In these cases, you know, it's up to the defense to show why he should get bond, to show how he should get bond, and to put forth a bond package that's acceptable to the court. So my guess is I don't think he's going to get bond on the third try either. And I think it's a very low standard where the prosecutor can show, unless the defense is coming with something phenomenal, it's a very low standard for the prosecutor to show, hey, listen, this guy shouldn't get bond because of X, Y, and Z. All they have to really do is make the allegations. Even with a hearing, you know, you usually have someone come up there and say, oh, look, he's making third-party calls, and they make a bigger deal of it than it is. And generally, they don't get bond. So I would say there's a 98% chance he doesn't get bond.
All right, so there you have it right now. I just wanted to reiterate the in the beginning, we talked about Tony Buzbee, and we talked about the fact that he is having a lawsuit filed against him and his law firm about having an extortion scheme for a large amounts of money. If a person does not, you know, do certain things, they're going to release fabricated evidence and things of that nature, and blame this particular male celebrity for some things and try to, you know, desecrate and their name. However, here with Diddy, man, you know, again, when you are, you know, presenting a bail offer to the court and you are on thin ice the way you are, you want to do it as less as possible. You know, anything to do with your attorney, fine. But anything outside of that, you got to let everybody know, like, hey, you know, I need everybody to chill for a minute, because right now I don't need to be talking to nobody. I don't need no extra attention. I need to talk to my attorney, focus on that. I got a bail hearing. I want to make sure that I'll get some things done. So, you know, it is what it is. I mean, at this point, I believe that I side with the attorney at the end, where he said that 98% chance that he won't get bond. I'm pretty sure he's not going to get bond. Even though it's $50 million, he putting up his house and doing all kind of stuff, you know, in Miami. At the end of the day, this is not, I don't think they're going to let this happen. So that is the video. Tell me what you think in the comments. Leave your comments below. Go ahead and like, share, subscribe to the channel. We got so much more for you this week coming up. We got some stuff live coming up this week where we're going to be talking about Courtney Burgess's lawyer. She had an interview on the Sean Atwood show, and we're going to have a live reaction to that as well. That part, and it's associated with the Diddy case as well. This is going to be pretty crazy. Until next time, I'm your boy Tay Biz. Peace. If you want more content from Tay Biz TV, go ahead and subscribe to the channel. Hit the notification bell, man. Peace.